Thank you, Mr. Hibner, and welcome, Ms. Corley and Mr. Johnson. Judge Bennett, Judge McBrayer, and I are pleased to be participating with you in this oral argument, which is being broadcast by live streaming and will be accessible later on as well after it's uploaded on the AOC website. We will conduct the hearing in the same fashion as if all of us were in the courtroom together. Each side has 15 minutes, and of course, Ms. Corley, as the appellant, has reserved some of her time for rebuttal. Unless there are any announcements, I'll ask Mr. Hibner to call the case.
Nathaniel Hicks et al. Versus Thomas Chears et al.
Ms. Corley, you have the floor.
So I'm Nancy Corley of the Nashville and Sumner County Bar, and I represent Thomas and Geneva Chears, the appellants in this case. I'd like to reserve 3 minutes for rebuttal. There's one misstatement I need to correct on the front end, and that is the fact that the Hicks did sign an answer. Their first lawyer did file an answer in this case. This case is a classic example of why people need lawyers. It is undisputed from the beginning that the Chears never gave written notice to the Hicks of their intent to exercise their option to purchase this property as required in the lease with purchase option. The basic issue in this case is why they did not do so. The basic facts are, in 2007, the Chears wanted to buy a house, and the Hicks had a house they wanted to sell, 1006 Curdwood. In October of 2007, Thomas Chears gave Nathaniel Hicks a $20,000 cash down payment on the house. And in the December of 2007, 3 of the 4 parties signed and had notarized a lease with purchase option that Nathaniel Hicks had bought from Home Depot. That agreement provided that the Chears would pay $1,600 a month to the Hicks for rent, of which $1,600 would be a down payment on the purchase price of $190,000. In effect, every payment made by the Chears was to buy this real property. The Hicks had bought this property in 2005 for $176,000 and had executed a mortgage in that amount. But in the middle of negotiating with the Chears, between the time that Nathaniel Hicks accepted the $20,000 cash down payment and the time that the parties, or 3 of the 4 parties, met in December of 2007 to execute the agreement, the Hicks refinanced the property for $197,500,000, which was $7,500 more than the $1,900 purchase price in the lease with purchase option. This first lease with purchase option was for 2 years and provided that at the end of the 2 years that the Chears would be holdover tenants at all of the same conditions and terms. The Chears continued in possession and paid their $1,600 a month. In December of 2011, the parties executed a second agreement, and that may not actually be an accurate statement. Lynette Hicks whited out the dates on the original lease with purchase option, put in new dates, and you can see on the agreement where the line where the dates are is partially obliterated by the whiteout, and you can see at the bottom of the last page the top arch of the notary seal from the first agreement. Again, the parties continued in possession, or my clients continued in possession, continued to pay the $1,600. In January of 2015, Lynette Hicks again whited out the dates, and again you can see the notary arch from the seal visible on that third agreement too. This agreement was for 4 years and added a term that the Cheers would pay the taxes and insurance. Thomas Cheers signed the agreement above his signature on the first agreement, but nobody else signed the agreement. So this basically is the basis of our contention that there was one agreement and one lease through the entire 10-year period. The summary judgment order of 125-19 is the one in which the court determined that there were 3 separate agreements and not one continuous agreement. All during this time, Nathaniel Hicks told Thomas Cheers that it was his house, told other people that it was his house, that they were buying it. And the Cheers made a significant investment in permanent improvements to the house, and I set those out in detail in the brief. In the summer of 2006, thinking that they had come close to paying the $190,000, Thomas Cheers started asking Nathaniel Hicks for a payoff balance, but Nathaniel Hicks never gave him one. First of all, he said there was interest and that he would need an amortization schedule, but the lease with the purchase option said nothing at all about any interest. I think the most telling thing is that in December of 2016, knowing that the Cheers were getting ready to exercise their option to purchase, and at a time when the Cheers were current on their payment, so they would have the ability to exercise the option, the Hicks refinanced this house again for $218,500, making it virtually impossible to sell this house to the Cheers for $1,990,000 and committing the anticipatory breach of the lease with purchase option. And at that time, the Cheers had paid the Hicks over $190,000. Well, the Cheers became suspicious and fearful that the Hicks were not going to follow through, so they quit making their monthly payments after January of 2017. This is the basis of our anticipatory breach claim against the Hicks. The law basically states, and I cite this in detail in my brief, is that a party to a contract can repudiate it by committing a voluntary act which renders them unable or apparently unable to perform the contract, when the words and conduct of one party amount to a total and unqualified refusal to perform. And when a repudiation occurs before the time when a contract requires a party to perform, the repudiating party has committed an anticipatory breach of the contract. And our contention is that that is exactly what happened in this case to the Cheers by the conduct and statement and acts of the Hicks, especially in refinancing the house for $218,500.
Ms. Corley, I want to make sure I'm clear about the execution of the 3 leases. Did Mr. Cheers execute each of the 3, and you're saying Mrs. Cheers? No. Okay.
No,
So
the only time anybody re-signed any of the 3 agreements was on the last time when Thomas Cheers only signed his name above his original signature on the first agreement.
Okay, so on the 3rd iteration of the lease with purchase option, Mr. Cheers signed, but Mrs. Cheers did not.
No, nor did Mr. Hicks.
Okay, and then on second one, did anyone re-sign that one, or they just use the same signatures? Okay.
They just used the same signature and basically the same piece of paper, because you can see the notary, the top of the notary seal on the paper.
Well, it looked like they always use the same piece of paper, right? They just widened
Yes.
out the date, and I suppose on the last one, they added that paragraph 37 dealing with, what is
Right.
it, property taxes. Okay.
Yes,
Yeah,
that
sure.
was the only change, and then the term was 4 years.
And Ms.
Um,
Corley, Ms. Corley, the notarization, there was only one notarization, is that correct?
The first agreement was notarized at the bank, Regions Bank, on December the 14th, 2007. It was not renotarized ever again, but you can see the top of the arch of the notary seal on both contract number 2 and contract number 3. So I'm running out of time, so let me get quickly to the causes of action. I've covered issue number 1, which is the anticipatory breach, issue number 2, which is the fact that there was one contract and not 3 separate contracts and those were all decided, those 2 issues were decided at a summary judgment, and I don't have to tell the court what the standard of review about that. But I do want to point out that in all of the causes of action that are listed in the 3rd issue, the facts that I reiterated basically are the basis for the factual actions of the Hicks that impacted the Cheers. And according to Tennessee Rules of Civil Procedure 5201, the court is to make findings of fact about the legal basis for their decision. And if you look at the findings of fact made by the trial judge on each one of the causes of action set out in our original counter complaint, they are utterly and wholly deficient. There is no basis. They are conclusatory statements only. And under those circumstances, the court is not required to give deference to the conclusions and decision of the trial judge. And basically, the court is free to make its own determination of the preponderance of the evidence, which is what we are asking the court to do on the causes of action that we set out in our complaint. So we have set out the facts on the anticipatory breach by the Hicks, the no payoff balance, the fact there was no interest, and the fact that they refinanced the house, taking it out of the reach of being able to be deeded to the Hicks. This one contract, and there are no findings of fact on our causes of action.
Thank you, Ms. Corley. We will hear from you again on rebuttal. Mr. Johnson.
Good morning, Your Honors. James Johnson for the appellees, Nathaniel Hicks and Lynette Hicks. For the most part, I agree with the facts that Ms. Corlew has set before the court. Where I disagree with those facts are when she talks about the amortization schedule being offered being requested by my client, Nathaniel Hicks. I think the testimony that is in the transcript shows that at the time Mr. and Mrs. Cheers started asking questions about how much is the payoff, an amortization schedule was prepared by a representative of Mr. Cheers. And that amortization schedule was given to my client, Mr. Hicks. The second part where I disagree with Ms. Corlew is the fact that regarding the notary seal, there was never any requirement that this document be notarized. The facts show that there were 2 leases to begin with. The first lease was in 2007. It had a 2-year term on it with an option to purchase. That option to purchase was never exercised. The second lease went into effect in 2011 and 2013, and it also had a lease to purchase option, or an option to purchase, which was never exercised, and that is what the trial court found. The third lease that is in contention here is the lease where the trial court says, based on the law, because the terms of that lease gave greater obligations or greater rights to the parties, she found that it was in fact a new lease. In fact, the new terms of that lease were that it went from a 2-year term, as the previous 2 leases had, to a 4-year term. The parties also agreed that they would pay the taxes and insurance under that lease. And the third change to the lease is that Mr. Cheers did in fact sign that third lease. Whereas the second lease, it was just as Ms. Corlew said, the parties just said, we'll white it out and we'll just agree to move forward. But the third lease, the trial court found, was in fact a new lease. Now, under the anticipatory breach, I want to address her first cause of action, the anticipatory breach. As the trial court knows, that is a fact question to be determined by the trier of fact. The trial court looked at all of those leases. The trial court looked at the first lease and noted that there had been changes to the first lease. The trial court noted that there had been, the terms of the third lease had been changed. And she noted that because those terms had been changed, therefore it was a new lease altogether, and that the first 2 leases had no impact. And she ruled that it was not a continued or extension or renewal of the first 2 leases. She also found that the Cheers never exercised their option under that third lease. They never gave written notice to the Hicks that they wanted to purchase. And I think the case law that we have cited in my brief, the Piney versus Tarpley case, says that if you're going to exercise an option, it must be absolute, it must be clear, and you must do it in pursuant to the terms of the agreement. The agreement specifically said that if the Cheers wanted to exercise the option to purchase the property, that they would give written notice to the Hicks. And the Cheers testified that they never gave written notice to the Hicks. In fact, that's how Ms. Corley started her presentation today. It is undisputed. They never gave written notice to the Hicks that they wanted to exercise the option to purchase.
Mr. Johnson, isn't it reasonable for the Cheers to want to know whether your client was going to charge interest, and if so, how much, before they committed to purchasing the property?
Your Honor, I think it's reasonable, but I think if you follow Ms. Corlew's argument to its logical conclusion, they already knew. Their position was that it was the $1,600 a month. Every payment went to the purchase of that property. And so if they wanted to know how much they owed, all they had to do was to deduct, from the $190,000, all of the $1,600 a month payments that they claimed they had made. So just by asking, saying, hey, how much do we owe? That the trial court found does not comply with the terms of the lease, and it did not comply with the case law of the Piney versus Tarpley, which says you must exercise your rights to that option according to the terms of the lease. And the lease clearly said that they would give written notice, which they never did. The case law that I've cited said the acceptance must be unqualified, absolute, positive, without reservation, and according to the terms of the option. The terms of the option were clear in that it said that the parties would give written notice within so many days, and they never gave that written notice. In the trial court, that was her findings. And she said because of that, there was no anticipatory breach at that point. But the trial court also found that at the time they began to ask, they were in default of the lease. They stopped paying on the lease. And the lease says that if you're in default, you cannot exercise the option to purchase. And if there are no further questions on that cause of action, I'll move to the next cause of action. The trial court found that the third lease was in fact a new lease. The Hicks contend that the first and second lease were simply renewals or extensions, and extended over into the third lease, and therefore the third lease was a renewal and extension. And as I said, the trial court has already said, no, it was not, because under the case law that we've cited, Raskin versus Dorick, 82 Southwest 2nd, 948, 1991 case, the Court of Appeal says that if the parties under a contract, if that are new terms and it provides a greater obligation or greater rights to the parties, then it becomes a new contract and it's not a renewal or an extension. And the trial court found that there were 3 new terms added to the contract. The first term is that it went from being a 2-year contract, which was the first 2 leases. The third lease went to a 4-year contract. And the first 2 leases did not require the Cheers to pay the taxes or the insurance. And the trial court says this third lease does require them to pay taxes and insurance. In fact, I cited in my brief, the court said, I was concerned about the new lease. She says, but when I look down and I see that Mr. Cheers, in fact, signed the new lease, then she said that her concerns were remedied at that point, because not only were those new terms added, but he, in fact, signed the new lease, the third lease.
Did Mr. Cheers have authority to bind the other party?
His wife to the lease? Well, Your Honor, I would have to say so. I mean, they were living together in the house.
So do you have a legal principle or a statute or a case that says because husband and wife are living in the same house, that the husband has the right to bind the wife to legal contracts?
I don't have any authority right now, Your Honor, but I would look at it this way. If he signed the lease saying, okay, we're going to continue to lease the property, that's what we're doing here, there was never any cause of action. Well, even if he didn't have that authority, the trial court still found that they never exercised the option to purchase the property and that they were in default of that lease. So he signed it in January of 2015. He had until 2019 to exercise his rights to purchase the property, but he never did it, and neither did his wife. So neither one of them did that.
To what extent, if any, did the purported third agreement affect the amount of damages awarded?
Well, the amount of damages that were awarded to my clients, they were awarded the unpaid rent that had not been paid during that time period. And also, Your Honor, the Cheers posted a 1-year bond while this action was pending, and so it did not really affect it. Only to the extent that
was your client awarded insurance and taxes based upon the third agreement?
No, they were not, Your Honor. They were only awarded the unpaid rents for the time period that it was not paid.
So did the trial court find that there was a third agreement, or did the trial court rule one way or the other?
Yes, the trial court ruled that there was a third agreement, that the January 2015 lease was in fact a new agreement.
So if it was enforceable, why didn't the trial court award taxes and insurance?
But my clients did not seek unpaid taxes and insurance. They only sought the unpaid rent.
All right, thank you.
Yes.
And did the rent amount ever change?
No, Your Honor, it did not. It was always $1,600.
If the Cheers did not sign the second lease, I mean, what effect did that have?
Well, the lease had a term in it that said that they would become holdover tenants, and that the terms of the previous lease would remain into effect. In fact, the trial judge addressed that issue. She said that because her view was because the first lease expired in 2009, they became holdover tenants, and all payments made up to between 2007 and 2009, she said they just became rent. They didn't have the right to apply those towards the purchase price because they never exercised the option. And then in 2011, when the second lease went into effect, they had until October of 2013 to exercise the option under that second lease which they did not do. It expired also. And so there was a gap between 2013 and 2015. And the trial judge said under that circumstance as well, all the payments made during that time period were simply rent. Now she said I think Ms. Quiller will agree with me on this, trial court said in her view that had they exercised the option at the end of 2009 or at the end of 2013, trial court says she probably would have believed that every $1,600 payment would have gone towards the purchase price. That's what the trial court said. And she said, but because they never exercised the option and they created a new lease in 2015, she said those previous payments were just applied to rent. And I will move forward on the remaining cause of actions as my time is expiring here. The trial court did, in fact, hold a trial, a full trial, and gave the Corlews an opportunity to present evidence on their causes of action for unjust enrichment, for fraud, and for breach of the implied covenant of good faith. On the unjust enrichment issue, I think that's a red herring. I don't think that's really applicable here because there was a written contract, and I think unjust enrichment applies in the event there is not a written contract. But the unjust enrichment is that the Cheers were contending that they made improvements to the property. However, they took the witness stand and testified that they were never encouraged by the Hicks to make those improvements to the property. And Mr. Cheers said, in fact, I did that on my own. I never asked anybody. I never expected them to repay that. So there was no unjust enrichment. Also, Mr. Hicks testified that they received the benefit of peaceful enjoyment and quiet living on the property. So the trial court said she saw no basis for unjust enrichment. She actually ruled, and that's in her findings of fact. On the issue of fraud, the trial court made a finding of credibility. As the court knows, you must show an intent to deceive another person in the event you're going to allege fraud. The trial court clearly, and in my brief I wrote this, she clearly said to Mr. Hicks and to Mr. Cheers, I have to first assess this case under credibility issues. And I find Mr. Hicks to be credible. She said, in fact, I think Mr. Hicks was trying to help the Cheers. And she said to Mr. Cheers, I don't find you to be credible. She said, I think that you're being somewhat naive here in thinking, that all of your payments were going toward this house. And I cited that in my brief. So based on the credibility findings, she found that there was no fraud committed by Mr. Hicks. She also found that there was no breach of the implied covenant of good faith and fair dealing. She said she did not believe Mr. Cheers' testimony, and she found Mr. Hicks to be credible. In fact, he was trying to help them. I'll entertain any questions if the court has.
All right, your time is up, Johnson. Ms. Corley.
So I think the most important thing that I want to address is the legal status of this agreement, which the Cheers never exercised. Mr. Johnson said that they had to exercise the option and they must do it pursuant to the terms, and it had to be in writing. That is all true. But the important thing that he missed is that the optionor is required to keep himself in a position so that he can convey the property to the optionee when he's called upon to do so. And that is the basis of the anticipatory breach in this situation. When Mr. and Mrs. Hicks refinanced that property for $218,500, they made themselves unable to convey title to the real property had they been called upon to do so to the Cheers.
So they didn't. Are you saying they didn't have the funds to pay off that mortgage?
There's no way to know that, Your Honor. But
wouldn't that have been your burden at trial to suggest? I mean, I understand what you're saying is that the mortgage now exceeded what the purchase option was,
right.
they very well could have had the excess funds available from other sources other than the payments to satisfy that mortgage and thus give clean title to your client. So I would think there would have had to been some proof in the record saying they didn't have the ability to pay off that forced mortgage, or showing how they didn't have the ability to pay off that mortgage.
Well, the proof in the record was that they had to refinance because they were unable to keep up with the payments because the Cheers were late on their payments. So there is some proof in the record of their financial ability. So again, our position still is that they made themselves unable to convey the property to the Cheers for $190,000. And that's the anticipatory breach.
Can you jump to the fraud claim quickly? What's the fraud basis for the fraud here?
The basis of the fraud claim basically is Lynette Hicks never signed anything. So this was an unenforceable contract from the beginning because she was the owner of the property. So that is, again, I think an element of the fraud. The other parts of the fraud are that all the way through this, Mr. Hicks told Mr. Cheers and other people that this is their property, that they are making decisions on it. They are buying the property. It's their house, encouraging them to take their actions.
All right. Thank you, Ms. Corley and Mr. Johnson, for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 1 p.m.
Thank you, Your Honor.